channel. This is Stewart Richlin from 420 Law Office, and today I'm going to be presenting a really helpful and up-to-the-minute discussion with DJ Kuti from CannabisSavesLives.com. Check this out. I think you'll find it inspirational, and I hope you'll find it useful.
Hello.
DJ Kuti, Stewart Richlin on the air. How are you?
Hey, I'm doing great. How are you?
Well, I'm doing just fine. You know, it's been a crazy week, and I really appreciated you being around last week. We had some audio difficulty, but the stream is there for people with the patience to listen to it. But this week's been crazy. In fact, I'll just start out our conversation with my first topic point, and that is I was consulted with today by a client who was fired from one of the major Southern California theme parks, and I won't say which one. The reason that the person was fired was because they were a medical marijuana patient. No accusation that they used marijuana at work, but just the mere fact that they were using marijuana at home seemed to give this company the justification to fire someone, which we're probably going to be taking on as a case. We're exploring the case now. And remarkably, I guess Bill Rosendahl, using the same logic, would be eligible for firing if he worked at a large majority of American corporations, having recently admitted or confirmed that he was a long-time medical marijuana patient, and that's the same Bill Rosendahl who is a city council member. Also this last week we had a revelation about campaign finances. Apparently there's a bunch of money from medical marijuana dispensaries and collectives that is accepted by California's Los Angeles's, proud representatives, which is okay under California law, but under federal law, I mean, they're accepting money from medical marijuana. That's a felony. Any comments?
Oh, very interesting. I mean, of course, people in all industries know that if you want to get the attention of your local politicians, the way you do so is you donate to their re-election campaigns. And so, of course, I would not be surprised at all to hear that a significant number of individuals have. However, having the feds remind these campaign committees that are soliciting funds that there is a certain amount of danger, no different, I guess, than the Cole memorandum or the memo from the ATF or when the DEA scares the landlords or the banks. They send these little reminder notices just saying, if you engage in this, you put yourself at risk of breaking these federal drug laws.
According to the Park La Brea News Beverly Press, Bill Rosendahl, 11th District, and Paul Koretz, 5th District, have admitted to accepting campaign contributions from medical marijuana dispensaries and their supporters. $8,900 from Rosenthal and $7,300 to Koretz. But I think that also wound up comprising a relatively large percentage of the total donations that either of these two even have received. But of course, they call it a campaign contribution. But you and I both know, as grown-ups, what it really is. The system runs on payoffs.
Yeah, well, I mean, I think that, these are pretty available records. When you make a donation to a political action committee of $99 or more, your contact information is public record.
Right.
It is going to, it's going to get reported. So it's hard to say that it's that. What I find more interesting and a bit more dangerous are those dispensaries that have not necessarily made an open contribution to somebody on the books, but those who have paid anywhere between $20,000 to $80,000 in cash to somebody who is a friend of somebody in City Hall, and that money gets divvied up among certain people, and it's supposed to be for some certain level of protection and or favoritism in the future.
Well, I haven't come across that. I play it pretty on the table. If someone made that kind of proposal to me, I would be very worried that person might secretly be taping me, or might be a representative of the bar, or basically trying to tempt me into going against my own ethics. And even if I felt I could get away with it, I don't think I'd be able to live with myself. I learned that a long time ago as a lawyer. We get a lot of temptation. And I got big temptation early on in my practice, where I was offered by the universe an opportunity to very easily snatch about $30,000 in fees that were on the table, that I really could have pretty easily engineered myself to get, but that really I shouldn't get. And I made the decision then not to take the $30,000. Believe me, the $30,000 was very tempting back then. That's like $100,000. And besides, there's lots of bills to be paid and everything else. There's all kinds of justifications people use for taking the wrong path. But I'm really glad I didn't take the path then, and I won't take it now. I think that may be dangerous to the powers that be. I think they really prefer someone who has their price. John Kennedy, I guess, didn't have a price, and that was a real problem for the powers that be. But as far as whether this is going to change anything at all in the city of LA, it seems like probably not. It's kind of like giving a donation at this point would have been like closing the barn door after the cows have all left, because we've got this new ordinance that's now been signed as of yesterday by Mayor Villaraigosa, which means that in 30 days, isn't it, we're going to have a ban.
Right. I don't think there was an urgency clause added to it. No. So if there's no urgency clause on this ordinance, then yes, it will take effect in 30 days.
So the deadline has been basically set for those people that want to join our suit. Those of us that are in the game already, we have 5 collectives that I'm currently representing in the matter, all of which you, Dejay, have analyzed and made an expert opinion about as a declaration. And we're going to continue the battle for those. And I was just meeting with another collective manager or two, and I hope to meet with some more to see who else wants to come on board. One of the things that we hold as a great deal of hope and energy and ammunition is the fact that the county and alternative case is very unashamed of the word dispensary, and very clear that patients have rights, and that dispensaries are legal, and that they've been kind of introduced into SB 420 by 11352.768, which is the section that talks about the 600-foot rule. And I love the way that the county/alternative case imports those two together and just simplifies the analysis. Oh, dispensaries are legit under SB 420 because the subsequent enactment of the legislature clearly shows that. Boom, done. And that answers a question that some city attorneys, and other lawyers have gone through hundreds of thousands of dollars of hoop jumping to try to figure out the answer to. So,
well, because what their main argument is they always come back to nothing in Proposition 215 allows for dispensaries.
Yeah, well, that's
true. And so that's the crux of their argument, and that's where they come from.
Right, and then the answer is except 215 was expanded by SB 420, which called for Attorney General guidelines for implementation of safety and security for medical marijuana safe access. So they also always give lip service in these recitations to how they are facilitating safe access. In the case of the City of Los Angeles ordinance, they're claiming that by merely permitting the 215 rights, essentially, and by permitting collectives of 3 or less, that they have satisfied their obligation under 215 and SB 420, which I think is false. And it's definitely not enough of a satisfaction under this county case, which came down just a day before the decision in the city of LA. So one of the things that the county case stands for is the fact that patients have a right to get safe access by dispensaries. Not a dirty word anymore.
Right, finally, yeah. And I hope that courts will continue to see that logic that, as consumers, regardless of what our health status is, we're not required to, grow our own rose hips or grow our own echinacea or grow our own coffee beans or our own apples or carrots or raise our own chickens and so why should every individual patient have this burden put upon them of figuring out how their medical cannabis is going to be individually grown for them? Nice in theory, doesn't work in practice, and we don't do it any place else in the way we consume in this country.
Sure. I mean, what percentage of our population live, on the farm anymore? It's probably 1% or less. So yes, because of recent cases like Colvin and Evergreen, which we lost due to its being taken up on appeal, but and the county case, I think that the current status of the law is not too bad, and it certainly has advanced even since when we got our first partial preliminary injunction about 2.5 years ago, which culminated, I guess, in December, about a year and a half ago. So my thinking is that there's some new kind of stuff in the arsenal that we have that I'll be happy to go over with Judge Moore. We've got just a bunch of new cases and a bunch of new ways to understand how to implement the people's will and the legislature's will with reference to medical marijuana in the state. What else have you heard? Heard any scuttlebutt? Have you heard anything from the collectives? What are they going to do? Have you heard? Is anyone talking about, we're just going to throw in the towel and close? Is everyone going to lawyer up and suit up and boot up and take on the city?
Well, I've heard different things. I guess maybe to take the audience on a very quick tour of what happened down at Los Angeles City Hall is they basically effectively passed a ban. And I guess the media has been reporting it different ways because as I've gone around to talk to people, people are confused. They seem to believe that if they're pre-ICO at this point, they're untouchable. And so what I've kind of explained to people, and you've seen in that email, is that the logic of the council and the reason that they actually voted yes on both bans is, one, the city attorney instructed them that there wasn't any conflict in doing so, and they voted on these two ordinances to go down two different paths. The all-out ban put forth by Jose Huizar and Mitch Englander, that one, as you said, was the ordinance signed and put in place by our mayor yesterday. The correct ordinance, the limited immunity ordinance, which was going to give rights to people on the pre-ICO list only and ban everybody else, that ordinance got kicked down the road and is going back to the Planning Commission for further exploration, et cetera, et cetera. And the idea, the way the council sees this happening in theory is that they'll institute this ban and they'll wait for the PAC decision and they'll see what happens with the PAC decision, and based on that, they'll either uphold Huizar's ban or they'll see what, if any, amendments and tweaks need to be made to Koretz's ordinance and move that one forward.
So you
So
don't think they're going
that's
to enforce either one until we get some indication from the courts?
no, I think they fully intend to enforce the ban until the PAC decision comes down. I think they feel justified in it. I don't, again, I don't see how it's going to work. Um, I don't see that the LAPD is enthusiastic about enforcement of this. I'm wondering if they're going to, if the LAPD is basically going to insist first that, since this is the city attorney's great idea, that they start with an enforcement letter, and that the LAPD be, a follow-up mechanism, but not the primary, launcher of any enforcement on these collectives. And I guess we'll wait and see what they do. So in the meantime, most of the people I talk to are a little confused about who is going to see enforcement and in what form that enforcement is going to come. Whether or not people are going to shut down, none of the people I work with are shutting down. Everyone I work with is prepared to take on whatever fight they need to, whether they're pre or post ICO. But I have heard from others that some collectives have just shut their doors and gone away. And I don't know who any of them are, and I don't want to speculate, but I will assume that,
In the
they were
past,
maybe...
in the past, it seems to have been the least compliant or the least dedicated.
Right, yeah, it's usually people who, they don't think they're going to pass muster. I always hear the speculation that people jump in and people open a collective knowing that the hammer can come down anytime they want. And I mean, I sat down in a meeting as a consultant, kind of brought in on the side on a meeting. And, at the time, there was this whole, the moratorium was just getting into place. And so these guys knew they were kind of jumping in a time of the game when there might be some enforcement on them. And they pulled out their calculator after I gave them my speculation as to how long it would be before they would try to enforce anything. And they did the math, and they said, we will open. And, so yeah, you're right. There are people that just figure, if it's worthwhile for however many months, they're willing to jump in. But those are the first people to say, I'm out of here as well. So, but no, everybody who feels as though they have a right to continue serving their patients and operate as a legitimate collective under California state law, they intend on making that intention known before a judge if they have to.
Yeah, I think it's interesting that what you really describe as a self-selection process, which sort of gets rid of the bullshit artists, and the way that people define themselves is going to be the way that they respond. If they define themselves as legitimate, then they're going to consider that they have something to fight for and fight about. So I think it's very interesting that you point that out, and I'm really happy that I asked. It seems like the people who are contacting me, of course, I've got a law office, they are interested in suing and stopping this outrage, which really will have effects such as either killing some people or putting certain people out of their homes, apartments, jobs. Some properties will probably be lost to foreclosure. There are a lot of domino effects to interfering with this industry. All the collective people who work for these collectives and their families are either going to create other jobs miraculously, give up and go on assistance, go into the black market. None of these things are really palatable, and it's really not what we want. But anyway, the city of Los Angeles, formerly such a wise beacon and formerly so open-minded and so at the cutting edge of rights, um, just completely went the wrong direction, and the people who are most affected are so confused, and some of them are very sick, and others of them are just not able to deal with and obtain the accurate information about what's going to be happening. But what's going to be, and we don't even know what will be happening as far as the enforcement pattern will be. In fact, didn't we have a pretty long situation where, like under the first ordinance or under the ICO, or before the hardship thing, there have been so many different attempts by the city to lay down the law, but that's never had any effect.
Yeah, and I know it's interesting you say that because, as you said, the people who are contacting you, they're interested in a lawsuit, and the people who are contacting me are interested in what I've put out there as, why don't we put forth a voter initiative and be very, very serious about putting our own ordinance in place, because I think we can address what the neighbors are upset about in a simple ordinance. I think we can make sure these collectives, no matter when they were open, it's not about old collective or new collective, it's about good collective, bad collective. And if collectives can have a fair hearing, that's a weed out. Like you said, it kind of weeds itself out. The people who are in it for the wrong reasons are not going to want to have a public hearing. They're not going to want to be transparent. And the ones who do have been asking for a fair hearing and offering transparency for years now. So I think we can resolve, hopefully, many things that way, because I think what we're going to see over the next few months and prior to the March election, the city election, is that the ban didn't get rid of the dispensaries. The ban didn't stop the lawsuits. And the neighbors are going to be frustrated that no regulations don't work, and a ban doesn't work. So we're going to have to try the next thing, which is let's put actual regulations in place. And so, I've been, as you know, from sitting on the working group, I already have multiple draft ordinances to work with, as well as, of course, my colleagues in other cities. And I've gotten a lot of calls and support for doing this. And now that the mayor has signed it, I literally can get started any day now. But, of course, the goal is to do it right.
Well, you guys have to support DeJay to do it right, and that's the next step. Is let's review who we are in the presence of. DeJay has really dedicated herself to her nonprofit, the Patient Advocacy Network, and you can see all about what she does at CannabisSavesLives.com. And I think that's a great idea, DeJay. I think that we absolutely need to go ahead and write our own law. That's one of the most unique things about California, is that we actually have this referendum process, the proposition process. We can write our own laws, and there's nothing that the legislature can do about it, and that's how we got Prop 215, and that's how we may need to go ahead and control the city of Los Angeles.
Yeah, Stewie, I'm very familiar with this. In addition to having the Patient Advocacy Network, which is a 501c3, I also am a co-director of Patients for Compassionate Use Policies. We're a political action committee, and of course, we would be doing this initiative under the political action committee. And I come from a background, I worked on Measure Z. I worked on an initiative in Berkeley. I have an extensive background in this type of work as well. And I have been approached for the last couple of years about, well, why don't we just do it like this? And the reason I haven't is because I really wanted the LA City Council to do it. I wanted them to feel like it was their idea. I wanted them to be able to politically pat themselves on the back for it. Let them get those campaign dollars that we're seeing going toward, Rosendahl and Koretz and that kind of thing. Because I'm not that kind of a political animal. At the end of the day, I just want to see a good ordinance on the books. And I've given the LA City Council every single opportunity possible to do the right thing. And when they voted on this ban and watching how they did it and how it all went down and what they said ahead of time before they voted on it, they're not going to do the right thing. And I know that I'm smart enough and strong enough to do it. So
Absolutely.
yeah, I hope, and so I hope your audience will get a hold of me. My phone number is there on the front page of CannabisSavesLives.org or .com. It will take you to the same website, and people can give me a call. And once I have the links, I've already met with the election clerk. I've already formatted the petition, and I know what process needs to be done and what clocks start ticking with the election clerk's office once I file the official petition language. So I'm working on that official petition language, and when I have it completed, Stewie, I definitely hope that you will be involved when people ask me what lawyer I would be using to give this a review. I, of course, said I would love for you to be the one to take a look at our ordinance and make sure that I've crossed all the T's and dotted all the I's.
I in turn would share it with 2 or 3 hand-picked people that I've been working with that I got to know through this last round of litigation, and we would turn it around real quick for you and give you any constructive ideas we can.
No, and I appreciate that. And I've been very honest with people. I said, we can't do this half-assed. There are going to be some real expenses with this campaign. We have to print this petition. It's not going to be, they're not going to just be able to match. This is not something where you just download something online or fill in a blank on a screen on a computer. This is a real hit the streets. We have so many days to gather so many signatures kind of operation, and to do so and to do it right, it will take some momentum and some capital, and I certainly want to be able to show some consideration to you and others for your time and energy and signature gatherers and so forth. And then, gathering the signatures, and I always tell people, gathering the signatures and getting on the ballot is only one facet of this. Because if we actually get it on the ballot, and of course don't want to launch this campaign if I don't think it's going to if I don't think it's going to happen, I'm not going to do it. But the next thing is once it becomes an actual item where people can vote yes or no on measure whatever, believe me, we're going to have the Jose Huizars of the community come out fighting. And these are people who are capable of raising hundreds of thousands, if not in the low millions of dollars. They're
Yep.
going to run commercials against us, TV commercials. And so if we're going to be really serious about putting our own law on the books, this isn't just like going to the festival or something. This is going to be a real uphill political campaign. And I just want to know who's in, because like I said, I'm smart enough and I'm strong enough, and we were able to make Measure Z happen in Oakland and Measure R happen in Berkeley, and I know I have the know-how to make our measure happen in LA, but it doesn't happen without, the kind of people like Richard Lee who will put their money where their mouth is and make something happen. So hopefully, like I said, people will get a hold of me, and we'll do this right, because like I said, the city isn't going to do the right thing. So if we really want our own ordinance in LA, I really think the only way to do it is for us to just do it.
All right. Well, there the gauntlet is down, and Dejay is the contact person, and her phone number is all over her website, so I feel comfortable throwing it down. The phone number is 323-334-5282. That's 323-334-5282. and check out cannabissaveslives.org. And is there a website for the political action nonprofit?
I've thrown up real quickly something on WordPress. I'm not very proficient with these programs. That's another thing. If people want to donate any of their skills, I'll take it. But I have the website compassionatepolicies.org.
Oh, is there something there at least, a placeholder, or is it just a
There
website
is.
that you're holding up? Okay,
There,
good.
no, there is. There's a WordPress blog there at this time. It just doesn't
Great.
look real sexy, but it is there.
Good, good, good. Well, everything you do is definitely very intellectually and compassionately sexy. So, and the other way too. Hey, so listen, keep up what you do, and let's stay in touch and stay on the same team. It is such a pleasure and honor to be on the same team and on the planet and in LA with you, Dejay. And
I feel the same way, Stewie. Thank you. You help keep me sane here.
well, thanks for sharing these good ideas, and you listeners, thank you so much for listening.
Hello, my name is Stewart Richlin, and I've been an attorney for about 25 years, focusing on the rights of medical marijuana patients for about 5 years. If our office can be of assistance with reference to any situation you have, please give us a call at 888-420-LAW-1. That's 888-420-LAW-1. Are you making any of the following mistakes with reference to medical marijuana law? Are you unaware of federal law and the strict prohibition against growing, selling? Are you aware of state law and the requirements with reference to nonprofit, etc.? And are you in compliance with your local municipality and county rules? You may need a compliance check. You may need an expert witness. I've been qualified in court to testify with reference to the corporate structures on medical marijuana. If you need any of the services that I've described, or if you'd like to confront your city in litigation, as we've done with the Los Angeles litigation, in which my office is one of the proud, successful plaintiffs' lawyers that obtained an injunction against the City of Los Angeles marijuana ordinance, please give us a call so we can be of service. Thanks for listening, and take good care.